of a controlled substance, and that's from January 10th of 2024. The indictment alleges you were previously convicted of aggravated sexual assault of a child, a first-degree felony, April 13th.
Notice how the judge immediately drills down into the level of offense. That's courtroom code for. We're about to talk about how bad this could get. And trust me, third-degree felony isn't a slap on the wrist. It's already serious, but with priors, that's a whole new battlefield.
Of 2009. What that means is if you go to trial in that case and you're found guilty, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? And then in cause number 24, DCCR 1549, you're charged with aggravated assault with a deadly weapon. Which is a second-degree felony.
Did you catch that? Prior conviction for aggravated sexual assault of a child. The moment the judge reads that out, the stakes go sky high. Why? Because priors don't just haunt you, they stack the punishment range like poker chips in a high stakes game.
From June 24th of 2024, that indictment alleges that same prior offense, which means in that case, if you're found guilty, the punishment would be enhanced to that of a first-degree felony, which is a minimum of 5 years in prison, up to 99 years or life in prison. Do you understand? I'm sorry. And then in cause number 24, DCCR 1550, you're charged with a first-degree felony offense of murder, and that offense date is June 24th of 2024. The indictment alleges that same prior offense, which again...
Look at the leap here from second degree to first degree. That's the legal system basically saying you've played this game before. So now we're upping the penalty box. Minimum 5 years, maximum 99 years, or life. Imagine hearing that and staying stone-faced.
This case would mean the minimum, well, in this case it would mean the minimum punishment would be 15 years if you're found guilty, up to 99 years or life in prison. Do you understand? And then finally, in cause number 24, DCCR 1551, you're charged with the state jail felony offense of abandoning, endangering a child, and that's from June 24th of 2024. What it means in that case, if you're found guilty, is the minimum punishment is 6 months in state jail, up to 2 years in the state jail prison. Do you understand? In all of your cases, I have plea bargain rejections that you've signed with Ms. Perazzo that shows that the district attorney has made offers if you wanted to enter pleas of guilty for a 45-year term in the murder and the aggravated assault with a deadly weapon, with a 20-year sentence in the manufacturing or delivery of a controlled substance case, and a dismissal in the abandoning or endangering a child case. Those 45-year term and 20-year term would all run concurrently if you wanted to enter a plea in those cases, which means all together at the same time. You have every right to reject those offers, have all of your cases set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject those offers and have your cases set for trial? All right, we'll get those set on the trial docket. Ms. Perazzo will...
Here's the deal on the table. 45 years for murder and assault, 24 drugs, and 1 case dismissed. Sounds brutal, but here's the kicker. They'd all run concurrently. Translation. He's serving time all at once, not stacked. Rejecting this offer? That's like saying, nah, I'll take my chances at the casino. But the house always wins.
Begin preparation for trial. Mr. Coleman?
Your Honor, the state anticipates filing a motion to accumulate or stack to the extent that we can under the law.
And I did relay that to
Okay.
Mr.
I'm not sure which of any of those would be
I think the drug case would be the only one that's
That
not
could-
out of that same
the same occurrence. Okay, and you've gone over that with him.
Yes.
All right, you can go back with the bailiff. We'll set your case for trial. Thank you, Ms. Perazzo. Good morning. Are you Robert Williams? And will your client waive the formal reading of the indictment? Mr. Williams, in cause number 24, DCCR 2371, You're charged with the state jail felony offense of evading arrest with previous convictions from October 24th of 2024. The indictment alleges you were previously convicted of evading arrest or detention March 21st of 2024. And how do you plead to that charge? And is that prior offense true? Are you entering your plea of guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And also, do you understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, yeah.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of evading arrest or detention with prior conviction. Sentence you in accordance with that agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices.
Pay attention. Here, this isn't just about a guilty plea. The judge is reminding him, no guns, no ammo, not even a hunting rifle in the garage. Under Texas law, once you're tagged with certain convictions, your Second Amendment rights go out the window. That's a life sentence of its own.
Qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Edward Sellers. Oh, yeah, did we? Or did we? Okay, never mind. Got it. Okay. All right, are you Edward Sellers? Okay. And I'm going to take judicial notice of the court's file in cause numbers 24 DCCR 0386 and 24 DCCR 1927. Mr. Sellers was evaluated for competency to stand trial previously and was found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from that facility dated November 27th of 2024. The finding in that is that Mr. Dunn is currently competent to stand trial. There's a report of competency evaluation included that has the date of October 20th of 2024.
Competency check. Courts can't try you unless you actually understand what's happening. If you can't tell a judge from a janitor, you're not going to trial. Here we see a defendant restored to competency after treatment, basically. The system hit pause, fixed the mental health piece, and now it's back to business.
This was prepared by Dr. Stephen Coates. Is there any other information with regard to competency?
No, Judge.
Ms. Malfino, so then at this time, based on that report, I will find that Mr. Sellers is currently competent to stand trial. And so you both mentioned that you probably need some more time in the case now that we have Mr. Sellers back, and so is a normal reset sufficient?
It is, Judge. Judge, Mr. Sellers did want me to inquire with the court about his bond. The issue is that he was evaluated while he was in jail. In the interim between the evaluation done and we getting the report back, he made bond. So he was placed on the bond docket, showed up for court, and he was taken into custody to go to the hospital at that time, Judge. So concerned about whether it's possible for that to be reinstated or something since he's completed his term at the hospital for his dealing with comments.
So what did I just raise it or find?
It's showing them on because
Right. They're both. So let's do this, since there hadn't been anything filed, I guess technically, we're gonna, Ms. Holmes is gonna do a little checking into kind of how, on both cases, to make sure both cases are kind of the same status, which one's made bond, what those bonds were before he was sent to the Dunn Behavior Center, and then I will take a look at it and see if there's something that I'm comfortable with going back to on that. That way I can review all the reports and things like that and take a look at it. If you'll just put it on my desk once we figure that out. All right, you can go back with the bailiff. DeAndre Thomas, Mr. Lewis. Good morning. Are you DeAndre Thomas? And will your client waive the formal reading of the motion?
He does, Judge.
Mr. Thomas, in cause number 23, DCCR 2048, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation February 27th of 2024 for the offense of obstruction or retaliation, third-degree felony, and that was a 4-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department August 13th, September 3rd, September 16th, and October 15th of 2024. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you provided a urine sample August 21st, August 29th, September 5th, September 23rd, and October 9th of 2024 that tested positive for tetrahydrocannabinol. And is that true or not true? Count 4 alleges that you failed to provide verification of performing the community services required. And is that true or not true? Count 5 alleges that you failed to provide verification of completing the anger management program. Is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true? And then count 7 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. Anthony Young, sentencing. Mr. Lewis. Good morning. Are you Anthony Young? And Mr. Young, you were previously in court